Assalamu alaikum, good evening viewers. Welcome to another edition of Legal Ease, where we make the law easy for you. This evening again, we've got a guest from the CCMA, a senior commissioner. We're going to be talking about conciliation, mediation, agreements at the CCMA, arbitrations at the CCMA. Often people have difficulty. They go to the CCMA, have agreements, have arbitration rulings, but parties do not comply with that. So part of the topic this evening is not only what is conciliation, what is arbitration, but also what are the agreements that come out of these, what are the rulings that come out of these, and the compliance orders and how they are enforced. Our guest this evening, welcome to the show, Senior Commissioner Mduduzi Khumalo, not new to ITV. You've been on the program with us before, and thank you very much for making yourself available again.
Thank you, Prof. I feel like I'm home already. I feel like part of the station.
When we came in, I said to our engineers and our producers here that our guest tonight needs no introduction. Most of the viewers will know him if they've seen the program before.
Yes, I was here before, and good evening to the viewers as well, and I'm happy to be here.
Okay. As I was telling the viewers, today we're going to be talking about conciliation, mediation. Maybe a good start. What is conciliation? What is mediation? There are other processes at the CCMA, but these are the two mostly used processes.
Prof, it's a very good question. You see, these are the questions that we always struggle with, because when parties come to the CCMA, they expect certain things. So this is the right platform for us to explain the conciliation and mediation and arbitration. Conciliation is a without prejudice process. This is so to encourage parties to engage freely to try and find a solution that is common and acceptable to both parties. So during conciliation, if it becomes necessary, and as a commissioner you feel that you may be able to assist the parties further to get to a settlement, you may go into mediation. In so doing, you go into the details of each party's case. So, but you need to be very careful. If your case is scheduled for CON-UP, you can't go into the details of the case. But if it is not CON-UP and it's conciliation, and we are confident as a commissioner that you may be able to assist them to facilitate a settlement in the mediation process, you go into mediation, you go into details of each party's case where you do the reality testing. But conciliation at length, Prof, is that it's a party's process. It's not a CCMA process. Commissioners are there to facilitate the process. The process belongs to the parties. It is the parties who take the decision on how the dispute is settled at conciliation. However, if dispute is not settled at conciliation, then the process moves to arbitration. At arbitration, it's a total different kettle of fish. You need to bring your evidence and you need to bring your witnesses. If you say, I'll just make a quick example. I am unfairly dismissed. And the employer says, I've never dismissed you. You as the employee must prove that you were dismissed. So you do so by bringing your own evidence. If there was a letter or an SMS or any type of communication that was made by the employer to you, you need to produce that as your evidence. But if you don't have it, you may lose at arbitration. The arbitration is a formal process where parties are required to produce evidence, and it is the commissioner who takes the decision. So I would say that is a commissioner's process. Right. So that is the distinction between the conciliation and the arbitration. Conciliation is the parties' process. It's an informal process where parties are allowed to explore possibilities of a settlement on their own, with the assistance, of course, of the commissioner.
Right. So conciliation, the commissioner has no ruling powers, purely tries to get the parties to reach agreement. The decision to reach agreement belongs to the parties.
Entirely to the parties.
And the commissioner cannot force employees or employers into an agreement.
That is a very important point, Prof. Because most of the parties will come back at a later stage and say, I was forced to withdraw or settle at this amount. The commissioner has no role. Right. He cannot tell you that we must settle for 50 Rand or 100 Rand. It is entirely your decision as a party to the process.
I suppose as part of the process, the commissioner sometimes put a bit of pressure on the parties to reach an agreement. And they see it perhaps as the commissioner trying to force them into
Yes, that is during the reality testing. Right. When the commissioner does the reality testing, the commissioner may say to you, are you confident we are going to be able to deal with 1, 2, 3 legal issues that are going to arise at arbitration? If you are not confident, I suggest that you settle. So it's just a suggestion.
Okay, and then
Yes.
arbitration, the commissioner makes a ruling, which is final, which is binding.
Yes, arbitration award, it's final and binding to the parties to the process, unless one of the parties take the ruling on review at the Labour Court.
Okay. One of the things you mentioned while you were explaining,
Yes.
is you talked about CONARB. Now, obviously, CONARB is conciliation arbitration.
Yes.
Normally, conciliation takes place. They then apply for arbitration, which takes place at a later stage.
Yes.
CONARB?
CONARB, it's a process. I think the legislature saw that the processes were taking longer because previously we would have a conciliation. After conciliation, the other party will have to go and apply for arbitration, another 90 days waiting for the date, and after the date, the arbitration process takes place. So the legislature tried to close the gap because if you read the Labour Relations Act, it says the CCMA and the bargaining councils have an obligation to speedily deal with labor dispute. So to try and close that gap, they came up with a CONARB. I think it was in the amendment of 2002 of the Labour Relations Act. And it has worked wonders where we are able to conciliate and arbitrate the dispute on the same day. So that means if the commissioner is faced with a CONARB, Prof, he cannot go deeper into details. He can try and conciliate the dispute at a very mild approach and say maybe these are the issues, but consider this in order to settle. But when the dispute is set down for conciliation only, he's allowed to go deeper.
All right.
Yes.
Okay, now at conciliation, you said parties are allowed to reach an agreement. At arbitration, the arbitrator makes an award.
Yes.
What's the difference between a conciliated agreement and an arbitration award?
A conciliated agreement is an agreement that is entered into by the parties that seeks to settle the dispute that exists between the parties, that is in writing, and that the parties have a right to take to arbitration should they not settle.
Yeah.
Yes.
Okay, so as suggested, agreement, that would suggest it's a form of a contract that the parties have
It's a form of
entered
a contract, yes.
Whereas arbitration award, the commissioner makes an award, which is
It's
like
more,
a judge making a ruling. Or
yes, it's more like a
giving
judgment.
Okay.
Yes.
In practice, what's the difference to the parties? Because now the parties have an agreement on the one hand as a result of conciliation. On the other hand, they have an award as a result of the arbitration. Both are enforceable, I suppose.
Both are enforceable. Yeah. The advantage with the agreement is that it is the parties who determine how the dispute is settled. However, with the award, it is the commissioner who decide what is fair and just.
All right.
Yes.
Okay, now we have horror stories sometimes. Parties come to you and they say, we had an agreement in the CCMA, I went to the employer, but now the employer doesn't want to comply. We had an agreement, I'll get my job back, or we had an agreement that the employer will pay me 1 or 2 or 3 or 6 months compensation. Now the employer doesn't want to pay me. What can I do? Or there's an arbitration award. But let's talk about the agreement first. Because on the other end, there's an arbitration award, and the employer doesn't comply with that either.
Yes.
So can you tell us a bit about
in terms of the agreement, if there's an agreement in place which has date of payment or date when the employer must comply and the employer does not comply, the employee has a right to approach the CCMA or the bargaining council to say the employer has failed to comply with an agreement, and our agreement as a CCMA has a clause that parties consent to Section 142 capital A, which is converting the agreement into an arbitration award.
Okay.
So if there is no compliance, the employee approaches us, we provide the employee with the Section 142 capital A form, the employee completes it and it's sent to the employer, and we convert the agreement into an arbitration award. And if still there is no compliance, the employee complete a section LRA form 718, which now we convert the arbitration award into an enforcement award.
Okay.
The enforcement award, it's like your court order. So if the employer does not comply, if it is monetary, the employee may approach the sheriff.
The sheriff. Yeah.
The sheriff will go to the employer's premises and attach the property of the employer to realize the settlement of the money that is owed and due to the employee. And if it is a performance by the employer, where the employer has to either reinstate the employee, once it is made an enforcement award, the employee must serve it on the employer to say that CCMA has issued an enforcement award, and if you don't comply, I'm going to court for contempt proceedings.
Okay, so even that's been made easier, because previously, you had to go to the labor court, you had to make made a court order, but now you can do it at the CCMA, you can do it through the commissioner. I assume it starts with the commissioner making it an arbitration award.
Yes, it starts with
It's not merely straightforward an administrator who does it.
No, it starts with the CCMA commissioner making an arbitration award, then an enforcement of the award, and if the employer still does not comply, then the sheriff will go and attach the property of the employer.
Okay, and that's now for the conciliation agreement.
That is for the settlement agreement.
Okay,
yes.
And the arbitration award, if there's no compliance with that?
If there's no compliance with the arbitration award, the employee will complete, the arbitration award will be enforced in terms of Section 143 of the Labour Relations Act, and it will be made an enforcement order, and the same process will follow. The sheriff will visit the premises of the employer to either attach the property of the employer, and if it is a contempt proceeding, the employee must just serve the enforcement of award to the employer, and if still there's no compliance, he can approach the court for contempt proceeding.
Of court. If there's no compliance, obviously then it becomes a contempt of court.
Yes, contempt proceedings in terms of Section 158.
Okay, we're going to go on. We're going to talk some more about this, but I just want to call viewers and give viewers an opportunity, because this is a topic that we know we often get questions about. People either phone us at home or phone us at offices. They want to know what they can do. We've had that. So viewers, we're going to give you an opportunity to call in if there are any questions that you want to ask Senior Commissioner Khumalo. The number is on the screen. It's 011 086 7777. Please call in if you have any questions, if you have any comments. We are talking about conciliation, we are talking about arbitration, we are talking about conciliation agreements at the CCMA, and the same would apply for the Bargaining Council, and we're also talking about arbitration awards where commissioners make arbitration awards and we often don't comply. It sounds like we have a call on the line. Assalamu alaikum, good evening. Hello?
Hello.
Hello, assalamu alaikum. Good evening. Go ahead.
Can you hear me?
I can hear you loud and clear. Go ahead with your question.
Okay. I went into an arbitration.
Right.
And my attorney advised me that a settlement agreement was the only way that disputes were settled.
Okay.
The commissioner accepted the settlement proposal,
right,
and the settlement agreement was signed.
Right.
Is the settlement agreement which is entered into in an arbitration lawful and valid?
Okay, you need to make a distinction between an agreement and an arbitration award. Agreement is an agreement between the parties, as Commissioner Khumalo explained. The parties enter into agreement with the assistance of a commissioner, whereas an arbitration award is something that the commissioner issues after having heard evidence. But
that is correct.
Right.
I heard the commissioner saying that the settlement agreements are only admitted in the conciliation.
Okay.
No, thank you, sir. I will answer you. The settlement agreement can be entered into in the arbitration as well. Are you there, sir?
Okay, you can
Yes.
go on. He'll probably listen
Yes,
on
and thank you for that question. It's a very important question. Maybe we omitted that. A settlement agreement can be entered into at any stage of the process, as long as the arbitration award has not been delivered by the commissioner. Once the commissioner has tendered an arbitration award, then the arbitration award takes precedence. But in the absence of, even at the end of the arbitration,
before the award is issued.
even on the 13th day, because the award must be issued on the 14th day, parties can elect to settle the dispute and advise the CCMA that, Commissioner, we no longer need the award, we have settled the dispute, there is our settlement agreement. It is valid and legal.
Okay, and we know also, viewers, that an arbitrator, a commissioner during the arbitration process can suspend the arbitration process.
Yes.
And tell the parties, give me an opportunity to conciliate or mediate and reach an agreement, and often they do reach agreement, or sometimes the parties say, Commissioner, hold back with the arbitration, let's not proceed with the arbitration.
True.
We think we'd rather like to settle.
True. Actually, it happens a lot in the arbitration where parties realize perhaps that it is better to settle at some stage in the arbitration process. So commissioners can suggest to the parties that, can we revert back to conciliation? And if parties consent, the arbitration can be suspended and the conciliation process be canvassed. But if parties do not consent, the commissioner cannot unilaterally demand that parties go to conciliation.
Because conciliation has to be voluntary, obviously, by nature.
Of course.
Okay, viewers, thank you. That's time for us to take a short break. After the break, we'll come back. We'll continue talking about arbitration awards and conciliation agreements. Be ready with your questions, be ready with your comments, and please feel free to call in. Viewers, welcome back. And again, just a reminder, we've got Senior Commissioner Khumalo, who's been with us before. We're talking about conciliation, we're talking about arbitration, we're talking about conciliation agreements, we're talking about arbitration awards, we're talking about enforcement of these agreements and awards and compliance. And on this screen, we will have the phone number. Please call in if you have any questions, if you have any comments. The number again is 011 086 7777. We've got a caller on the line. Assalamu alaikum. Good evening.
Hello.
Hello.
Assalamu alaikum.
Wa alaikum salam. Go ahead with your question.
Then I've worked for a company for 15 years.
Okay, can I ask you to please mute your TV, put the TV off because it's interfering with the sound. There's an echo.
Okay.
Okay, go ahead with your question.
I've been working for a company for 15 years, and I've basically been fairly dismissed. I had a hearing at the DRC, which was referred to as settlement, which the company till today has refused after 4 months. So I've applied now for a labor hearing. So what happens after that?
Okay, did you hear the
I
question?
did not pick it up.
Okay, could you just repeat the question again, please? The line isn't very clear. We didn't hear the question clearly.
Okay, I was working for a company for 15 years.
All right, you're working for a company for 15 years.
And after 15 years, I got unfairly dismissed.
Okay, you were dismissed and you believe that it's unfair, right?
Right. I took it to the DRC, which is part of CCMA and stuff.
Sorry, you took it, where did you take it to?
To the
DRC.
DRC, because I was working
okay, so to the Bargaining Council,
the
Dispute
Bargaining
Resolution Council.
Yes.
Yeah?
And the commissioner said that we either do a settlement with the company or else refer it to the labor court. There was no arbitration.
Okay, what was the reason for the dismissal?
They said the company was closing down due to financial difficulty, but till today the company has not closed down 5 months later.
Okay, so it was a retrenchment, sounds
Operational
like.
requirement.
Yes.
So
Yes.
it's what we call operational requirements. Is it a big company?
Yes, yes.
Was anybody else retrenched?
No, just myself and my sister.
Okay, so more than one person.
More than one person, yes.
Okay, Commissioner Kumalo will deal with that.
Yes. In terms of the Act, if the company goes through an operational requirement dismissal and it is a big company, a big corporate, obviously the dispute will be conciliated either by the CCMA or the bargaining council, unless it is one only, one employee. But if it is more than one employee and it's a big corporate, then it goes to the labor court. But if it is a small business, maybe a company that employs 10 or so employees, and it has retrenched more than 10 employees, those employees can elect to have the matter arbitrated by the CCMA. But if you listen to the caller, hers was a big company.
Yeah. And more than one person.
More than one person, and that is why the commissioner said they should go to the labor court.
Okay, are you still on the line? If not, the answer, as you can hear, because it's a big company, because more than one person was retrenched, the process is conciliation first and then referral to the labor court. If you were the only person that was retrenched, then you could elect to have it arbitrated at the bargaining council.
Yes.
Okay. Now, we sometimes get real horror stories. We get people reaching agreements at the CCMA or at the bargaining council, now that that has come up. Through the commissioner, they have a settlement agreement. It goes away. Employee comes back and say, I was pressured into this agreement. How do you deal with something like that?
Look, as a CCMA or the bargaining council, our role once there's a settlement agreement and there's a complaint is to investigate the complaint. That is all we can do, but refer the employee to the labor court. It is only the labor court that has powers to set aside a settlement agreement that is reached at the CCMA or the bargaining council.
Okay.
But we investigate the complaint, and if indeed there is some maybe unfortunate incident that had taken place in the process, obviously the CCMA or the bargaining council are expected to take serious action against the commissioner concerned. Okay. Commissioners are held at a very high ethical conduct that they must never influence the process in any way or force people to settle in any way. And if they have any interest in a dispute that is before them, maybe you are my cousin, you come to CCMA, I must disclose before I start that Prof is my cousin, employer, are you comfortable that I proceed with the hearing? And if the employer says, no, I'm not comfortable. At times the employer will say, I'm comfortable, but I won't be comfortable. I would say, no, let me recuse myself and get a colleague who will be impartial and neutral to come.
We'll have more about that. We've got another call on the line. Assalamu alaikum, good evening.
Wa alaikum salam.
Go ahead.
I called a little earlier and I was cut off.
Okay, sorry about that.
I'd just like to pick the commissioner's brain here again.
Go ahead.
I agree when he says that in conciliation and mediation, the worker is not protected because there are no rules in the LRA regarding conciliation and mediation. But in the arbitration stage, the law is very prescriptive and it says that the arbitrator must arbitrate. So where does the settlement agreement fit in the arbitration?
Okay, just a response. Maybe you weren't clear on the response. During the arbitration process, the answer was that a commissioner can, with the agreement of the parties, say, let us revert. We're not stopping the arbitration. We're just stopping the arbitration shortly. Let's revert to conciliation. If we don't settle, we'll continue with the arbitration. That's what the process is. Do you want to add to that?
Yes, that's what the process is. And he's right when he says the commissioner has no powers at arbitration to direct the parties to conciliation. Because once the certificate is issued by the CCMA that the dispute is unresolved, the powers to conciliate by the CCMA is no longer there. Only if the parties consent to go to conciliation will the commissioner be able to revert back to conciliation.
And that's what we said, viewer, that at that stage it then becomes a voluntary process where the parties consent to the conciliation. If they don't consent, the commissioner must proceed with the arbitration.
Okay, well, what I'm saying is that in many instances in the arbitration, a settlement agreement suddenly appears. Attorneys on either side may just produce a settlement agreement and tell the worker that this is the only way to do it, and then the poor worker signs it. And there's no record by the commissioner of having reverted back to conciliation or anything. Now, is a settlement agreement under those circumstances lawful and enforceable?
Okay, I hear what you're saying, yeah.
It's an interesting comment that you're making. However, if parties are represented at arbitration, obviously it is the attorneys who will approach the commissioner and say, Commissioner, can we revert back to conciliation? And the commissioner cannot say no to parties. I mean, the attorney, in terms of our record, is representing the interest of the employee or the employer. So he may have taken instruction from the client to come and approach the commissioner to say, can we revert back to conciliation? Yeah. So the commissioner has no powers to say, no, you cannot.
Yeah, and we hear your concern as well, because sometimes the attorneys tell their clients that you don't have an option, but the commissioner doesn't know that. The only thing the commissioner knows is the two attorneys who are representing the clients come to the commissioner and say, we've settled, like a settlement out of court, but this is a settlement outside of the arbitration process. So we've settled, we've got an agreement, and therefore we do not wish to proceed with the arbitration. It's their choice. There's nothing the commissioner can do about it.
Yes, the commissioner can.
Okay.
Yes.
Right. But Jazakallah for your question. Very important, very interesting question.
Yes, I think there's a lot of education that we need to do out there for the clients to understand that it is their responsibility to instruct, not to take instruction.
Okay, we've got another caller on the line. Assalamu alaikum, good evening. Hello.
Hello, Assalamu alaikum.
Wa alaikum salam. Go ahead with your question.
I called just now while I was talking to the commissioner, right?
Right.
Where I said I was unfairly dismissed and my case is going to the labor court.
That's right.
I wanted him to explain to me what happens once it goes to the labor court and how long does it take for the matter to be resolved.
Okay, interesting question.
Very interesting, and thank you for the question. The labor court has got its own rules. And once you file your application at the labor court, then you must follow the rules, you must file all your papers, and once the case is ready for prosecution, the court will then set a date for the hearing, and then the case will go to trial, and the judge will then decide. Normally, the intention is to get the case decided within 6 months. Sometimes it's difficult, depending on the parties and their commitment and the availability of judges.
Okay, previously labor court processes used to take very long, 2 or 3. We heard stories of it taking longer than that. But over the past 2 or 3 years, they've speeded up the process, and it's usually within sort of 6 months that it takes place. But you need to constantly talk to your attorney and make sure that they follow up to see that the case is taking place at the labor court.
Okay, thank you so much.
Jazakallah for your call, thank you, and appropriate time to take another break. And viewers, after the break, please be ready with your questions, with your comments for Commissioner Khumalo. Assalamu alaikum again. Good evening. We're back on with Senior Commissioner Khumalo again. A reminder, or if you've just switched on, we're talking about conciliation, we're talking about arbitration at the CCMA, and for that matter, at bargaining councils. We're talking about agreements, we're talking about awards, the processes, and enforcement of these awards. And we've heard sometimes that parties reach an agreement and later they're unhappy with the agreement or there's no compliance. But let's see if we've got callers on the line. Assalamu alaikum. It sounds like we've got 2 callers on the line. Assalamu alaikum. Hello. Assalamu alaikum.
Wa alaikum salam.
Go ahead with your question.
I just want to find out from you whether you take body corporate complaints.
No, this is only labor disputes in terms of the Labor Relations Act, in terms of the Employment Equity Act, CCMA matters, not
It's
other
not
legal
body
matters.
corporate. It's not body corporate, eh?
No, that would be, but we can talk to the producers. We can do a program on that perhaps at another time.
I'll
Inshallah.
appreciate it. Jazakallah.
Jazakallah for your call. Another call on the line. Assalamu alaikum. Good evening.
Good evening.
Go ahead with your question.
Yeah, my question is, I had a brother who was working for a very big company.
Okay.
Now, working for this company, he was kicked out of his job. First thing is, there were two cases there at the CCMA. There was a case of people who had done something wrong, and there was a case of him traveling in an area where we are supposed to have traveled with the company truck.
It's breaking up. It's not too clear.
But I am following so far.
Okay.
Yes.
Go ahead.
Okay. Now, in this case, he said the commissioner put the case together, and the settlement amount for the people who were caught stealing something and him traveling on the wrong route were put together and they were given a settlement fee. Was it fair? Because I said to him, I don't think it was fair for two cases that what are not the same. Where people have stolen something and he was on the wrong route. That could be put in one consideration. And I asked this from the commissioner.
Okay, if you heard the question, go ahead.
Yes, I heard the question. Thank you for the question, sir. I think there are two things. His brother was charged for maybe being on the wrong route, and the others were charged for theft. And however, when they got to the CCMA, both cases were joined. Right. And as a result, he believed that his brother got the wrong end of the stick. Look, the joinder can be made by application by the parties, either before the hearing or viva voce, verbally in the process itself. So the employer may come into the process and say, I would request to join the two cases, and the other party will be given an opportunity to respond. And if they are amenable to the request by the employer, then the two cases will be joined and be dealt with together. But if the facts are not the same, like he's saying, and maybe the dates also are not the same, it's not possible.
Okay, so the answer is if the dates of the offences were, or alleged offences were separate, then you can't combine it. In order to combine the cases, it must be by agreement between the parties. The commissioner can't force it on them unless it's the same incident, the facts are the same, the charges are the same company, then only it can be joined.
It can be joined, yes.
Is that other caller?
However, if
we've got another caller on the line, we can come back to another caller on the line. Assalamu alaikum, good evening.
Hello, good evening.
Go ahead with your question.
Just tuned into the program now.
Okay.
I've got a case. I put in my case last year in beginning of 2016, and the issue was just resolved now. I was awarded a settlement.
All right.
Now my employer, he never responded throughout the whole process. Suddenly today he phoned me, telling me that he wants to pay me installment. Of which I was like, no, I'd rather take the case to CCMA. I even phoned the sheriff, the one who went to collect stuff from him. I was just taking advice from all over. And the sheriff told me that, look here, looking at your boss's assets and the money that he owes you, he doesn't have, his assets and your money are not equivalent. His ways were like, you might end up with less money than what he's supposed to pay you. So I just wanted to know, I mean, I'm entitled to a certain amount. Is it fair for me to get less than what I was awarded by the commissioner?
Yeah, look, it's obviously not fair because you're supposed to get more, but because the assets are not enough, you're going to get less. But I'm not sure. How do you deal with a case like that?
Yeah, the other thing is, I know this, my boss, is what assets are. I mean, I'm not very 100% sure about the legalities, but what I know is his business and his personal assets are all attached. He's got cars and so forth and boats and what. Can something be done so that I get my fair share?
Okay, so sometimes that happens. People apparently have assets, but it's not on their name, it's not on their registered name. They drive big cars, they live in big houses, they've got all types of things in their businesses. And when the sheriff comes to a test or, look at these things and they say, but this is not my property. I'm not sure how to deal with it.
I think one thing is that maybe the caller should also investigate if the company, are there company cars?
One, there is with two that are company cars that they use on a daily basis. Then it's with two that are personal.
So the company cars would do company business?
Yeah, the company cars do pay company business, yeah, the trucks.
So do they form part of the attached properties?
Yeah, and I wouldn't know, man. I mean, I don't have the specific details, but he doesn't even drive them because these are company, cars. Yeah, that's driven by employee.
Yes, you see, when the sheriff goes to the employer to attach, the sheriff writes down all the assets that he got in the employer's premises and he gives you a return of service. So you will be able to see what exactly the sheriff has attached. And if there are any omissions, you have a right to say, Sheriff, you have omitted A, B, and C. I know it's there and it belongs to the company. If it's a company truck and leaves at 7 in the morning, you tell the sheriff that, Sheriff, be there before 7, you will find that company truck.
Okay, yeah,
Yes.
I did that because I told him there's parties, they leave before 8, and sometimes they come to the factory, but most of the time, if he goes there before 8, you can see the parties, so I don't know.
Okay, so unfortunately, sometimes you have to do a bit of your own investigation and inform the sheriff that the following assets belong to the company and therefore the sheriff needs to take note of that. For example, if there's a company truck, if they're company cars, you need to tell the sheriff, the following cars, if you can take down the registration, inform the sheriff that the following vehicles form part of the assets of the company, the sheriff will then know what to do with that.
Yes,
Okay,
thank you.
Thank you.
Right, thank you for your call. We've got another caller on the line. Assalamu alaikum, good evening. Hello? Okay, that caller's gone. We can go. But some interesting things came up here. Now, sometimes, people earn a lot of money, above what the threshold is, that 200 and some odd thousand a year. Sometimes people earn below that threshold. Does it make a difference in enforcing arbitration awards or settlement agreements? Do the CCMA or bargaining councils offer a bit extra assistance for people below the threshold?
Yes, Prof. Actually, in terms of Section 115 of the Labour Relations Act, CCMA offers administrative assistance to employees who earn below the threshold. That means if you earn below the threshold, you don't have means to maybe serve your employer with your referral form, which is a 711, you can ask the CCMA employee to assist you to serve the form, but it remains your responsibility as an employee in terms of the law that you ensure that the form is served on the employee. So you cannot go to a process where the employer claims that I did not receive the form and say it is the CCMA's fault.
Right.
So immediately CCMA has served the form, you need to peruse the form and make sure that it went to the correct address.
Okay. So you can in fact tell that CCMA person, clerk or administrator that's assisting that I want to prove that it's been done.
Yes.
But before we deal with that again, another caller on the line. Assalamu alaikum, good evening.
Wa alaikum salam. It's me, the arbitration man again.
Okay, go ahead with your question.
Okay. Does a settlement agreement have to comply with any rules? I mean, it can't ask you to kill your mother. Just
Well, it must be lawful, obviously. Any agreement
in fairness and equity and so on. And secondly, assuming if the settlement agreement says it will be made an arbitration agreement,
Yeah. An
or
arbitration
arbitration
award.
award.
Yeah.
And that is not done after several years, and the bargaining council doesn't even have a copy of it. What is the state of that settlement agreement? Thank you.
Okay, a lot of years is perhaps dragging it out. Once the agreement is in place, obviously the employer will go to the employer and say, you know, I need to be paid in terms of the agreement. If it's not paid, as Commissioner Khumalo said, you then go back to the bargaining council or the CCMA. The commissioner will then make it an arbitration award. Once it's an arbitration award, you follow the process of an arbitration award to have it enforced. And in terms of your question about can anything be in there, it must comply with the same. What's a valid
legal.
contract?
Yes, it must be legal and enforceable.
Yeah.
Because if it's not enforceable, we can't help you. It can't have words like as soon as practically possible.
Yeah.
Because we don't know what
That's vague. What does that
that's very vague.
Yeah.
So it cannot be enforced. So it must be precise and concise to the point what exactly the party's intention is. So if the employer fails to comply, you know that you are supposed to be paid on the 10th of July and 10th have passed and there is no payment and the employer has not made an effort to contact you to advise you as to why the payment has not been made. You have then a right to approach the bargaining council, the CCMA, to say, can we enforce? But where you have lost the agreement, it does not change the fact that there is an agreement. It remains there. So parties has to try and find the agreement. And if they cannot find the agreement, I'm sure they can ask the assistance of the commissioner who drafted the agreement.
Okay,
and normally the file is at the CCMA, the bargaining council will have the original copy of the agreement.
Okay, usually the bargaining council, the CCMA, cannot tell you that the award has been lost. Because even if it's lost, at least the commissioner will have a copy of the award and that can be made available. But we can continue with that after the break. Time for a break again. Viewers, be ready with your questions, with your comments. And if you want to follow up on that, questions about arbitration, you're welcome to do that. Please call in again and we'll be prepared to assist where we can. Assalamu alaikum, good evening. We're back on again, viewers, with Senior Commissioner Khumalo. We're again talking about the conciliation agreements, arbitration awards. If you have any questions, please call in. If you have any comments, please call in with your questions, with your comments. The number is on the screen, 011-086-7777. Okay, some interesting questions we've had about enforcing arbitration awards, forcing agreements, and we sometimes get people saying, I entered into agreement, I was forced into it, and you were dealing with that. You said that the person can go to the labor court.
And have it set aside.
And have it set aside.
Yes, but as the CCMA and the bargaining council, our role will be to investigate the complaint.
Okay.
Yes.
Because it may be that a commissioner is guilty of some misconduct.
It may be, yes,
Right.
it may
So
be. We don't rule that out.
Yeah.
Yes.
So it will be investigated, and clearly, if the commissioner did something wrong, disciplinary action will be taken, and the agreement. Can the CCMA then set the agreement aside?
No, they cannot.
Okay, it will still have to go through the labor court.
Yes,
Okay.
yes. But the CCMA may terminate the commissioner if indeed they,
Right.
because most of the commissioners are part-time commissioners. They are not full-time employees of the CCMA. So CCMA cannot take disciplinary action against them. They may just terminate the contract if the commissioner has misconducted himself.
Because the commissioner is in breach of contract,
Yes,
obviously.
yes.
Okay. So viewers, again, if you have any questions, please call in. Then for arbitration awards, it's the same. You go to the labor court if it's not enforced, or?
No, if it's an arbitration award, you come to the CCMA for enforcement of award, and we give you the enforcement. You go to the sheriff goes and attacks the property of the employer. But if it is a performance, as I said, you just have to serve it on the employer that CCMA has issued an enforcement. Do you want to comply? And if the employer still insists or ignores the enforcement, then you go to court in terms of Section 158 for contempt proceedings.
Okay, but the viewer called in earlier about restrictions on arbitrators, on commissioners. Commissioners are restricted into how much they can award in terms of an arbitration award. There are limits. You can't say, 6 years compensation, or you can reinstate, you can compensate. What are the limits?
In terms of Section 193 of the Labour Relations Act, the primary remedy is reinstatement. Right. Where there's a dismissal and the dismissal is substantively unfair, then the commissioner can reinstate. If the parties have proven that the reinstatement is not possible, the commissioner can compensate. Compensation varies from 1 day to 12 months.
Okay.
Yes.
But up to a maximum of 12 months?
Yes, that's a maximum.
Okay. But the Labour Court can award more than 12?
Up to 24 months.
Up to 12 months. And that would be cases of automatically unfair dismissal?
Yes.
Things like unfair discrimination?
And cases of disclosure, protected disclosure of information.
Okay.
Yes.
So, and that would be your whistleblowers, right?
Yeah, whistleblowers,
okay.
Yes.
Or sort of union membership. If you're dismissed because of union membership, I suppose that falls under
automatically unfair dismissal.
Automatically unfair dismissals, yes. As well. We've got a caller on the line. Assalamu alaikum. Good evening. Go ahead with your question.
Okay. I would like to ask about Malikum Salam. Yeah, I would like to ask about if there are various parties involved in arbitration.
Right.
And say 5, 6 people, and then if one of the parties don't pitch up, what happens in that case if you go through the arbitration way?
Okay, there's usually arbitration in labor disputes. There's usually 2 parties. Sometimes there are more. It would be either employees or more than one employee, or one employee represented by a trade union, or themselves, or sometimes represented by a lawyer. On the other side, you'll have the employer, who either represent themselves or represented by a lawyer or by an employer's organization, and they bring witnesses to the arbitration. So I'm not sure when you say the various, do you have cases like that perhaps?
Yes, we do. Because of the amendment in the labor
with the labor brokers,
yes,
and
labor brokers, yeah. And their clients,
right.
They can both be cited as respondents in a process. But my suspicion is talking about employees where you have more than one employee, right. In a dispute, and instead of 5, only 4 shows up. What happens to the one employee who did not attend the hearing?
Right.
In that case, and if it is an arbitration, the case of that employee will be dismissed because the employee is absent. The commissioner will deal with the case of the 4 that are present in the hearing.
Okay. Are you still on the line?
Yes.
Okay. Does that answer your question?
Yes, answer my question, yes.
Okay. Jazakallah for your question.
Jazakallah.
Wa alaikum salam. Another call on the line. Assalamu alaikum. Good evening. Hello. Go ahead with your question. Hello. It sounds like we lost a viewer. Okay, it sounds like the caller's gone. Okay, let's continue talking about the arbitration awards. Then, of course, there's things like execution costs, and where does that fit into this whole thing?
The legislature also identified that as a challenge because most of the employees, particularly those who earn below the threshold, cannot afford the expenses of enforcement. So an assistance was introduced that if the employee earns below the threshold, the CCMA can assist the employee in the enforcement of the award with the cost of the sheriff and perhaps storage and so forth. But however, if there are other applications that happened during that process, the CCMA cannot deal with those. But where the enforcement, payment of sheriff fees and the storage fees, the CCMA has been given the powers to assist the employees who earn below the threshold.
Okay, so anybody earning above the threshold, it's for their own expense.
The law believes that if you earn above the threshold, you can afford an attorney, an advocate, and so forth. But if you earn below the threshold, which is at the moment is 205,433, it's just around 17,000 a month.
Right.
So if you earn below that amount, the law believes that you need to be assisted in order to assert your rights.
Okay, because if you didn't have that assistance, you wouldn't be able to afford it. And of course, then justice will not be done.
Then it makes the mockery of the process that we are in. So in order to keep the CCMA relevant, it was important that these amendments were done to the legislation.
Okay, but again, I think you need to, we touched on it, but I think perhaps you need to sort of warn parties when it comes to signing settlement agreement. What are some of the things that they need to be really careful about?
Parties need to look at whether the settlement agreement that they are signing represent their intentions. Because at times parties get excited and just sign. They need to read the agreement that, as I made an example earlier, you find an agreement, it says the employer will re-employ the employee as soon as it is practically possible. That agreement is useless. And if you sign that agreement, you cannot enforce it anyway. So you've actually thrown away your case. So at all times, before you sign the agreement, the commissioner must read the agreement to you and say, Clause 1, this is what the parties are agreeing to. Clause 2, accurately reflect the intentions of the parties. And if in any of the clauses, your intentions are not properly reflected, you have a right to say to the commissioner, Commissioner, can you change that? This is what we meant by this. And the commissioner must make sure that the agreement is legal and enforceable. And parties, it remains your responsibility to read the agreement that you sign and understand it. Where you don't understand, ask the commissioner to explain what this means. And commissioners are discouraged from using legal jargon when they write agreements. They are encouraged to use simple and clear English to say, if it's reinstatement with a back pay, it must just say so that the parties can understand what they are expected to do in terms of the agreement.
Okay, we'll come back. There's a caller on the line. Assalamu alaikum, good evening.
Wa alaikum salam.
Go ahead with your question.
If an arbitration reverts to conciliation
Right.
For the purposes of a settlement agreement,
Okay.
surely the commissioner should record that agreement somewhere. Because the probability that arises here is that the attorney can go behind the client's back. Maybe it's the dangling contingency fee or whatever, but he can go to the commissioner behind the client's back and make an arrangement for a settlement agreement which the client is not aware of. Secondly, regarding compensation. Compensation is ordinarily defined as payment for damages. But in terms of the Labor Relations Act, I believe that it is only punitive action which leads to a claim for damages. Can the commissioner please explain?
Okay.
This is a very good caller.
Right.
He knows his stuff.
Okay.
But look, if you have a challenge with your attorney, there is law society that attorneys are held accountable. And if your attorney at any time during the process misrepresent your interest, you have a right to approach the law society. But the commissioner has no right or reason to question your attorney. The commissioner labors under the impression that the attorney represents your best interest at all times, unless you advise the commissioner during the process that, Commissioner, I and only I will talk to you with regard to the settlement, not my attorney. So then the commissioner can approach you every time there is a suggestion of a settlement. But in our law, once the attorney is admitted into the record as your attorney of record, that attorney represents your interest throughout that process. And
Okay,
if
there's two scenarios here. The one is the attorneys on their own reach agreement outside of the arbitration, during the arbitration, but away from the commissioner. They reach an agreement, they come to the commissioner and they say, we've reached an agreement, you don't have to proceed with the arbitration. That's the one scenario.
Yes.
The other scenario is they tell the commissioner, look, instead of continuing with the arbitration, please conciliate because we believe we can settle. In that case, the commissioner will assist with the drawing up of the agreement and will have it signed. The commissioner will sign as well because it's done in the presence of commissioner. Is that not the way it works?
Exactly, yes. But in all processes, once the attorney has been presented as your attorney of record, we cannot question the attorney. Right. But there is law society that holds attorneys accountable. And if you believe that the attorney has misrepresented your interest in any way, you have a right to approach the law society. The second issue was where the commissioner record if the commissioner switches off the recorder in order to allow parties to canvass settlement. Once settlement has been concluded, the commissioner will go back to the record and enter that into the record.
Okay, yes. I think that's we've come to the end of the program. Commissioner Khumalo, thank you once again for having made yourself available. I hope we can call you onto the program again another time, and we'll either continue with this or we'll add to this another topic. Viewers, thank you very much for your questions. Thank you very much for being with us. Inshallah, we'll have another program next week, Wednesday, when Ashraf will be with you, and the week after that, inshallah, I'll be back with you. All the best. Assalamu alaikum wa rahmatullahi wa barakatuh. Jazakallah, and thank you very much, Commissioner.
Thank you, Prof, and thank you to the listeners. This time went very fast. I was still enjoying myself.
Sure.
Thank you.